Good afternoon. Thanks everyone for coming. A tremendous turnout on such a beautiful day. Thank you very much. I'm Philip Munoz. I'm the director of the Center for Citizenship and Constitutional Government, and it's my pleasure to welcome you to today's lecture. The Center seeks to cultivate thoughtful citizenship through research and teaching about the principles of American constitutionalism and constitutionalism more generally. We do this in a number of ways. We have an undergraduate minor here in constitutional studies. Any undergraduates in the audience, if you're interested in the things we're talking about today, please come talk to me about the undergraduate minor. We have a student fellowship program, about 24 student fellows. They meet with our speakers. They'll have breakfast with Professor Witte tomorrow morning, and they receive mentoring and beyond the classroom seminar series and all sorts of things. So if you're interested in getting more involved with the center, again, please come talk to me. And then we have our public lectures, a third component of what we do. And I'm especially excited about this one. We're inaugurating something today. This is the first True lectures, something we will do repeatedly. So the story behind the name, it's a wonderful couple, Notre Dame family, Tad and Jennifer True. Jennifer, class of 96. Tad likes to say he took a fifth-year victory lap, so he's class of 97. They came to me a year ago and said, we'd like to do something to help Notre Dame become the university it should become. And I told them what I just told you. We have a fellowship program, we do the minor, we do all sorts of things. But I said, look, Tad and Jen, there's one thing that you should do that no one else could do, which is you should endow a lecture series, and we'll call them the True Lectures. And we're doing this to contribute to Notre Dame's mission of being the very best Catholic research university in the world. What I said to Tad and Jen is, if I had my way, we'd have the ability to bring in the world's most distinguished lecturers to Notre Dame, and not just to talk about what they have published, but we bring them to Notre Dame to present new work they're working on. And they come to Notre Dame for a number of days, and they would present their ideas. They get feedback from our faculty. They'd meet with our students. We'd have a week-long conversation. And if that conversation goes well, we'll talk to Steve Rinn over at Notre Dame Press, and maybe he'll send out the manuscript for a review, and we'll actually generate scholarship. And we'll call it the True Lectures. And they said yes, and that's why we're here today. So I am deeply grateful to the True family, especially Tad and Jen. They can't be with us today, but I think they're watching live, so thank you, Tad and Jen, for your generosity in making this possible. When they said yes, I knew immediately the person I wanted to deliver our first lectures. And I'll let our student introduce Professor Witte, but let me just say, John, thank you for accepting the invitation. We have quite literally the world's most distinguished church-state scholar who doesn't teach at Notre Dame Law School. And I'm just thrilled that we're beginning in this way. So thank you, John, for your time. Three other people I want to thank. Professor Rick Garnett, the most distinguished church-state scholar at Notre Dame. He's co-sponsoring our lectures here, his Church, State, and Society Center, and thank you for Professor Garnett. Professor Garnett is also going to be offering some commentary. There's a third session that's just for faculty, and Professor Garnett will be offering commentary. Also, thank you to Professor Don Drakeman, another eminent church-state scholar who's flown here today to be with us for the lectures and to offer commentary as well. One last person to thank, Don Stuletto. I was going to say he was probably out stealing food from Michael Bradley's lecture. Don's the co-director of the center, and which means he does everything. So Don has been working very hard to make all this possible. So Don, thank you, and please thank Don with me. If you don't like the food, blame him. Okay. We have a tradition here at the center, which is we have one of our undergraduate students introduce our lecturers. So Eric Gordy Eric Gordy is majoring some things, but really he's considering becoming a constitutional studies minor. Right, Eric? And he'll introduce Professor Witte.
John Witte, Jr. is Woodruff University Professor, McDonald Distinguished Professor, and Director of the Law and Religion Center at Emory University. A leading scholar of legal history, human rights, family law, and law and religion, he has published over 300 articles in 45 books, including The Blessings of Liberty, Human Rights and Religious Freedom in the Western Legal Tradition, published by Cambridge University Press in 2021, and Religion and the American Constitutional Experiment, published by Oxford University Press in 2022. In addition to these inaugural True lectures at Notre Dame, Professor Witte has delivered a number of prestigious lectures, including at Yale, Berkeley, McGill, and Oxford. The title of his lecture today is The Great Awakenings of American Religious Freedom, Evaluating the Latest Supreme Court Teachings. Please join me in welcoming Professor John Witte.
Well, thank you so much, Philip and Eric, for your very warm and generous introductions and welcome here. Good afternoon to all of you. It is a joy to be back here at the University of Notre Dame and to have a chance to see some old friends and to see a number of new faces and a number of names whose writings have inspired me over the many years. It's a wonderful place to be, and I am envious in my little place at Emory University. What an honor to stand here at the True Family Lectern as your inaugural lecture, no less. My deep thanks to the True family and to other generous supporters in the creation of this important lecture series. And thank you for your charity in not vetoing the committee's selection of the inaugural lecture this year. What a privilege to be a guest at the Center for Citizenship and Constitutional Government. Thank you so much to Don Stiletto and his colleagues for their generous hospitality and for their skillful choreography of our time together here and tomorrow. What a joy to be with Philip. Philip is one of the nation's great scholars of religious freedom and church-state relations. His recent University of Chicago Press book, Religious Liberty and the American Founding, is going to be one of those rare books that will be read 100 years from now and edifying still to those who are privileged to pick it up. And it's a delight to be here with my dear old friend Rick Garnett, with whom I have been collaborating in adjacent rows in the vineyard for an awful long time. We've worked together, we've lectured for each other, we've co-authored things together, and it's a joy to be with you again, my friend. Thank you for allowing me to be with you and to be part of a conversation with you in these next couple of days. And a new friend, Professor Don Drakeman, whose writings have inspired me for many years, but whom I've had the privilege to get to know in person over the last few months, and the trenchant commentary and criticism and engagement that you get from a Professor Drakeman is something that makes the Academy a wonderful place to be. If you have any hard questions after my lectures, if you would please put those to Professor Garnett or Professor Drakeman, and they will be able to handle them easily. If you have softball questions, I'll see if I can handle them, but they will pick up any of my inevitable fumbles. In the next couple of days, I will be addressing the theme, The Great Awakenings of American Religious Freedom. And the term Great Awakening has been used by American religious historians since the 1840s to describe movements of revival and reform and renewal and even revolution in American religious life. And these reforms feature not only returns to old texts and traditions, principles and practices, but also reforms that remove what has become old and outmoded and ossified and sometimes arbitrary and abusive. But it's not just a term for American religious history. Catholics among you will know the great awakenings of the Catholic tradition, driven by great popes like Gregory VII and Leo XIII and John XXIII, and great councils from Nicaea to Trent to Vatican II. And Protestants among you will know about the great awakenings of the Protestant Reformation and the evangelical revival movements in 18th and 19th century America. Like religion, law too has its own great awakenings, often born of revolution and revolt, tumult and tragedy, many times interspersed with and sometimes even inspired by religious revival movements. And these great awakenings have produced monumental legal documents, from Magna Carta to the Petition of Rights to the U.S. Constitution to the UN Declaration of Human Rights, and several hundred more with which I could bore you as a legal historian. My focus today and tomorrow will be on one such important legal document, the First Amendment to the United States Constitution, which reads, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." Tomorrow, I want to spend a little time looking at the first awakening of this document, its genesis in the 18th century founding era, and trying to discern what is clear and not so clear about those original 16 words, as we have them discussed, debated, ratified, and implemented in the period circa 1776 to 1791. Today, what I want to do is to spend a little time on a reawakening of First Amendment religious freedom over the past decade, a reawakening engineered by and proclaimed by the United States Supreme Court. Only a dozen years ago, American religious freedom was in trouble in several states and federal circuits. There, religious parties were excluded from state scholarships and vouchers and other public programs and benefits. Old religious monuments and art and books were targeted for removal as badges of bigotry and Christian favoritism. States' civil rights commissions were imposing massive sanctions on conscientiously opposed vendors for not servicing same-sex weddings, religious pharmacists for not filling prescriptions for abortifacients, religious hospitals for declining procedures affecting sex and procreation, religious charities for allegedly discriminating in their delivery of social services. Some critics and legislatures were calling loudly for religious communities to be stripped of their tax exemptions, marriage solemnization rights, and social service contracts. Several states, up to 20, enacted new anti-Sharia and other anti-Muslim policies. And all along, from the mid-1980s to about 2010, the Supreme Court sat largely quiet, leaving most religious freedom questions to be worked out by state and local governments and legislatures in accordance with the court's new devotion to federalism and separation of powers. There were many reasons for this turn against religion and religious freedom in the day. Worries about militant Islamicism and perhaps other faiths after 9/11, massive sexual scandals and cover-ups within some churches, media exposures of the luxurious lifestyles of a number of religious leaders sitting on fat tax-exempt properties, blatant political gamesmanship by some religious groups. A stronger reason still was that some folks opposed the rapidly emerging constitutional rights of same-sex liberty, equality, and marriage. Some faiths also opposed old constitutional rights to contraception and abortion. Strong critics in the academy and in the elite media now branded religion as an enemy of liberty and decried religious freedom as an outmoded and dangerous constitutional luxury. All that has changed dramatically. While loud criticisms of religion continue to clatter in the media and in the elite law reviews, the U.S. Supreme Court has led a great awakening of American religious freedom. In more than 24 cases over the past decade, the court has used both the First Amendment and federal statutes to strengthen the rights of religious organizations to make their own internal decisions about employment and leadership and employee benefits. It has held that government aid to religious education is not only permissible, but sometimes required. It has struck down several laws that discriminated against religion, that penalize parties for taking religious stands or that coerce parties to act contrary to their conscience. The court has insisted on both individual and corporate exemptions from general laws that substantially burden religion and conscience. And the court has strongly increased the protections available to the religious rights of prisoners. These 24 cases signal a decisive return to America's founding axiom that religious freedom is the first freedom of our constitutional order and not a dispensable second-class right. The 18th century founders' vision, which we'll talk about a little more tomorrow, was that religion is more than simply another form of expression and association. It deserves separate constitutional treatment. The founders thus placed the guarantee of freedom of religion before the freedoms of speech, press, and assembly in the First Amendment. All peaceable exercises of religion, the founders repeatedly said, whether individual or corporate, private or public, traditional or new, popular or reviled, properly deserve the protection of the First Amendment. The current court has embraced this traditional teaching with new alacrity. The current court has also embraced the traditional view that the First Amendment provides an interlocking and integrated shield of religious rights and liberties for all. The First Amendment Free Exercise Clause outlaws government proscriptions of religion, actions that unduly burden the conscience, that unduly restrict religious expression and activity, that discriminate against religion or has the state invading the autonomy of churches and other religious bodies. The First Amendment Establishment Clause, in turn, outlaws government prescriptions of religion, actions that unduly coerce the conscience, mandate religious exercise, discriminate improperly in favor of religion, or has too close an alliance between the state and the church. The First Amendment guarantees of free exercise and no establishment of religion thereby provide complementary protections to, and indeed embody, some of the other constitutive principles of the original American experiment. Principles like liberty of conscience, religious pluralism, religious equality, and separation of church and state. In the 1940s, the Supreme Court had confirmed all of these founding principles when it opened the modern era of religious freedom case law, an earlier moment of a great awakening of religious freedom. But in the 1980s and 90s and early 2000s, the court gradually reduced the First Amendment to a mere guarantee of state neutrality toward religion. That provided some protection, but not much. Today, the court provides far more robust and principled protection. This is not just a revival of founding teachings, as we'll talk about a bit tomorrow. It also reflects fresh insights and accents that the Supreme Court has been grappling with as it seeks to create a more unified, if not integrated, framework for the protection of religious freedom. 5 distinct teachings are worth highlighting as we watch the pieces of this emerging framework. One teaching of these recent cases is that a regime of religious liberty must respect historical democratic judgments about religion. The court has used arguments from history and tradition before as parts of broader rationales for upholding traditional religious tax exemptions and Sabbath day laws and legislative chaplain prayers, all of which were commonplace in the founding era. In the Town of Greece versus Galloway, a 2014 case, however, the argument from historical democratic decision-making became the key basis for upholding a local community's decades-long practice of offering prayers by invited local clergy to open its town council meetings. A local taxpayer thought this constituted an establishment of religion. The Supreme Court disagreed. The First Amendment must be interpreted by reference to historical practices and understandings, Justice Kennedy wrote for the court, particularly those that have, quote, withstood the critical scrutiny of time and political change. A test that would sweep away what has long been democratically settled would create new controversy and begin anew the very divisions along religious lines that the Establishment Clause seeks to prevent. The 2019 case of American Legion versus American Humanist Association used similar logic. That case featured a large Latin cross that had been privately erected in 1925 as a memorial for local soldiers who had died in World War I. But it now stood at a prominent intersection of two major public roads that had grown around it in the ensuing decades. The American Humanist Association thought this major Christian symbol constituted an establishment of religion that should come down. A 7-2 court, led by Justice Alito, rejected this claim. The court agreed that the cross is a poignant Christian symbol. But this Latin cross, Justice Alito wrote, in place for nearly a century, has taken on independent value as an embedded feature of the community's landscape and identity. For some, this cross was a symbolic resting place for ancestors who never returned home. For others, it was a place for the community to gather and to honor the sacrifices made by the members of the community. For still others, it was just a familiar historical landmark. When the passage of time, Alito wrote, imbues a religiously expressive monument, symbol, or practice with familiarity and historical significance, that gives rise to a strong presumption of constitutionality. The upshot of these and other recent cases is that the First Amendment does not give a disgruntled taxpayer a heckler's veto over long-standing democratic decisions the local community took to create and maintain a religious symbol or ceremony or practice. Change might well come, but only through legislation, not through litigation. When you think about it, many areas of American law respect the power and passage of time. Historical preservation and zoning rules grandfather older uses of property that do not comport with current uses. Adverse possession and prescription rules of property allow an open, continuous, and notorious use of property to vest in the user. Statutes of limitations and res judicata rules promote finality and the closure of old disputes. The equitable doctrine of laches bars claims from parties who sit on their rights too long. Similarly, in constitutional law, tradition serves effectively as something of a null hypothesis, requiring that a challenged practice or policy be overcome by strong constitutional arguments rather than discarded by petty invocations of principle. As Oliver Wendell Holmes once put it, if a thing has been practiced for 200 years by common consent, it will take a very strong case under the Constitution to unearth and remove it. This argument from history and tradition has been strong enough to support the continuation of chapels and chaplains in legislatures, military bases, state prisons, public hospitals, and embassies, old decalogues and menorahs and creches and ceremonial Indian mounds on state and federal parks, religious verses and cross sayings and figures in public monuments or on public buildings, religious iconography on official coinage or stationery, ceremonial recitations of oaths and proclamations and pledges that invoke the name of God and other transcendent language. So long as private parties are not coerced into participating in or endorsing this religious iconography, and so long as government strives to be inclusive in its depictions and representations, there is nothing wrong, in my view, with a democratic government reflecting and representing the traditional religious values and beliefs of its people. Yes, some old traditions, no matter how venerated, eventually have to go when they no longer represent a community's values. As the nation saw with the removal of Confederate flags from Southern Capitol buildings or the renaming of public structures built on the backs of bloodied slaves and named for their abusive masters. But many old, innocuous, and avoidable religious symbols and practices can and should stay. Accommodating old religious traditions in modern American public life can sometimes be a bit messy and clumsy. It's always easier to start over, especially when standing at a clean blackboard or opening a new document or starting the first page of your new law review. But as Justice Souter reminded us, the world is not made brand new every morning. We are heirs and stewards of traditions, stories, institutions, and practices. And in a rule of law state that respects precedent and orderly procedure, we are obligated both to maintain these traditions and institutions and to reform them only with trepidation, only with explanation, only with full understanding of what inspired that old practice or symbol and what will inform its replacement. A second corollary teaching of the court's recent cases is that government may not coerce parties into supporting or participating in religion, even old and venerable religious traditions and practices that have won widespread democratic approval. This is in part time-honored First Amendment teaching. The law is absolute in forestalling compulsion by law of the acceptance of any creed or any practice or any form of worship. So said Justice Roberts in the Cantwell v. Connecticut case, the 1940 case that opened the modern era of religious freedom. Later, free exercise cases that struck down compulsory flag salutes and mandatory recitations of the Pledge of Allegiance and state-administered test oaths as forms of religious coercion. Later, free speech cases held repeatedly that government cannot induce or coerce private parties to express themselves contrary to their religious beliefs. And that proposition informed the court's most recent free speech case of 303 Creative LLC versus Alanus, which protected a website designer from furnishing and advertising her wedding services to same-sex couples. Even a party who operates in the stream of commerce cannot be forced to say or display something that violates their core religious beliefs. If you run a billboard, government can't tell you what to put on your billboard. Same thing with a website. And later, Establishment Clause cases insisted that young, impressionable public school students, under mandatory school attendance orders, could not be coerced to participate in religious teachings or prayers or Bible readings or religious symbols as part of their classroom and curricular experience. The court's recent cases have confirmed this prohibition on religious coercion. But the court has also raised a threshold on when freedom from religious coercion can be successfully pled under the Establishment Clause. In Town of Greece, the court made clear that the brief, solemn, and respectful prayer offered by an array of local pastors before a town council meeting was not religious coercion. It was, the court said, simply a way to lend gravity to public proceedings and to acknowledge the place that religion holds in the lives of some members of the community. No citizens were coerced or compelled to engage in the religious observance. They could easily skip the brief prayer before the meeting or simply ignore the prayer they may have heard with impunity. Self-help was thought to be the better course of action. Yes, some secular citizens might be offended by the very presence of these old religious ceremonies, Justice Kennedy recognized, just as some religious citizens might be offended by the various secular and sometimes anti-religious messages that we all have had to endure. In a free speech culture, blasphemy is one of the costs of freedom. But offense, Justice Kennedy said for the court, offense does not equate to coercion. Adults often encounter speech they find disagreeable, and an Establishment Clause violation is not made out any time a person experiences a sense of affront from the expression of contrary religious views or anti-religious views. 5 years later, Justice Gorsuch made a similar argument in his lengthy concurrence in the American Legion case. Indeed, he argued that without proof of actually being religiously coerced, offended bystanders should not even have standing to press Establishment Clause cases. The better course, he said, is for the offended reviewer and viewer to avert his eyes, close his ears, and pursue a political option. A third key teaching of the court's recent cases is that religion deserves not just state neutrality, but equal treatment and protection by government. The court has not formally rejected the 1990 Smith-Peyote case that introduced the free exercise test that neutral, generally applicable laws are constitutional no matter what burden they happen to impose on religion. But the court now judges any differential treatment of religion as fatal discrimination under the Free Exercise Clause or fatal viewpoint discrimination under the Free Speech Clause. And the court has repeatedly rejected government's argument that differential treatment of religion is needed to avoid an establishment of religion. Disfavorable treatment of religion by government is unconstitutional discrimination. Full stop, is what the court has repeatedly said. This focus on equality over neutrality is clearest in the recent Supreme Court cases on state aid to religious education. You have Nicole and Rick Garnett here, and they can tell you a lot more about this stuff than I. But as they will tell you, I think, such aid has long been a vexed topic. Before 1940, 35 of the then 48 states had passed state constitutional prohibitions on government funding of religious education. And after 1940, the U.S. Supreme Court joined them and struck down many forms of direct and indirect state aid to religious schools, parents, and children as violations of the First Amendment Establishment Clause. That has now changed dramatically. The court now holds that state aid to religious education is not only permissible under the Establishment Clause, but sometimes required by the Free Exercise Clause to ensure equal treatment of religion. The opening case in this series is Trinity Lutheran versus Church versus Comer in 2017. There, the state excluded a church school from a state program that paid for rubber resurfacing of school playgrounds. The Lutheran church school applied and qualified for the funds. They were eager to protect those little Lutheran knees from bruising and bloodiness, from falling off the jungle gym or the swing, just like everyone else. But the state denied them the funds because its state constitution prohibited state funding for religious education. And that had long been a standard Establishment Clause line. The Trinity Lutheran Church saw this as a violation instead of the Free Exercise Clause. The church school was denied a grant simply because of what it is, a church, said Chief Justice Roberts. State laws that impose special disabilities on the basis of religious status alone are permissible only if the state has a compelling interest for so doing and a general concern about violating its own state or federal prohibitions on religious establishment is just not compelling enough in the abstract. The court repeated this ruling in Espinoza v. Montana in 2020 about religious schools participating in a tax credit program, and again in Carson v. Macon in 2022, allowing quote-unquote sectarian schools to be available to parents who wanted to send their children to school but had no public school to which to send them. The court has also used the free speech equality principle to uphold private religious expression in other contexts. In the 2022 case of Shurtleff versus City of Boston, for example, city officials had allowed over the past 15 years some 300 groups to use the City Hall Plaza to gather for their own private functions and to put up their flag on the city pole during the time of their function. When Shurtleff and his Christian group sought to use the plaza, however, the court gave them use of the plaza, but said you could not put up your Christian flag because that would be an establishment of religion. Shurtleff claimed religious discrimination under the Free Speech Clause, and a 9-0 court, led by my old liberal professor, Justice Breyer, agreed that Boston had committed viewpoint discrimination against religion. The court's insistence on equality also guided its review of free exercise challenges to the myriad COVID regulations that placed restrictions on public gatherings, movements, and activities in those grim years a few years ago. Using its emergency docket, the court upheld such restrictions when they fell equally on religious and non-religious parties, but enjoined them when religion was treated differently. In the 2020 case of Roman Catholic Diocese versus Cuomo, Catholic and Jewish groups challenged the New York governor's order that created different tiers of restrictions on public gatherings depending on local pandemic levels. The plaintiffs argued that the governor had made disparaging remarks about the Orthodox Jewish and Catholic communities and had gerrymandered the restrictive zones to ensure that they covered their particular neighborhoods. Moreover, these regulations placed no comparable capacity limits on purportedly essential businesses in these same restrictive zones, including acupuncture facilities and transportation centers and manufacturing plants. This law, the court says, singles out houses of worship for especially harsh treatment, and the court issued an injunction. Similarly, in the 2021 case of Tandon versus Newsom, public health orders prevented more than 3 households from gathering for private worship, but allowed for larger house gatherings for business meetings and parties. It's California, after all. The court struck this down, too, citing the, quote, clear rule that government regulations are not neutral and generally applicable whenever they treat any comparable secular activity more favorably than religious exercises. Equality concerns also informed the court's sensitivity to evidence of state hostility against religion. That was part of the court's concern in the Cuomo case, given the governor's overt anti-Semitic remarks. A concern also informed the court's judgment in the controversial Masterpiece Cake Shop case of 2018. Here, a private cake shop owner refused to bake a wedding cake for a same-sex couple on grounds that doing so would violate his religious beliefs about the sacrament of marriage. He was heavily fined, his business was threatened with closure, and he became a public pariah. In a public hearing of the Colorado Civil Rights Commission that had brought the claim against him, one commissioner characterized the baker's views as, quote, one of the most despicable pieces of rhetoric a person can use, and compared it to past uses of religion and religious freedom to justify all kinds of discrimination, whether it's slavery or whether it's the Holocaust, quote unquote. The baker claimed violations of his free exercise rights, and a 7-2 court agreed, led by Justice Kennedy, who had authored several earlier opinions supporting same-sex equality and eventually marriage. The Free Exercise Clause, Justice Kennedy wrote, outlaws religious hostility on the part of the state itself. And here the commission betrayed clear and impermissible hostility toward the sincere religious beliefs that motivated this religious baker's objection. Such hostile remarks may properly be taken into account in finding discrimination contrary to the principle of equality. And concern for animus against religion also informed the court's majority opinion in the 2022 Kennedy versus Bremerton School District case, where a public high school coach was fired for offering a private prayer on his knees on the 50-yard line after the game was over. And while everyone was engaged in a cacophony of discussions about everything from how lousy the play was to where they're going to go to the bar and to all manner of other things being said loudly at the same time. Court said, here a government entity sought to punish an individual for engaging in a brief, quiet, personal religious observance, doubly protected by the free exercise and free speech clauses of the First Amendment. The Constitution neither mandates nor tolerates that kind of discrimination. Tradition, no coercion, equality. I got 2 more. I'll do 1 maybe if we're running out of time or patience before some concluding reflections and Q&A, which is the more fun part. A fourth teaching of these cases is that sometimes equality is not good enough to guarantee religious freedom. And in those cases, exemptions from compliance with general laws are needed. That too was traditional lore. Already in the 18th century, the founders recognized various customary and legislative exemptions that provided parties who had scruples based on belief with an oasis of nonconformity, a space to follow the dictates of their conscience or the commandments of their faith community. The founders thus granted various exemptions from religious taxes and oath swearing and military service and sometimes Sunday laws. These exemptions continued in both federal and state statutes throughout the 19th and 20th century. In the 1963 case of Sherbert versus Werner, the court went further to create judicial exemptions to relieve religious parties from substantial burdens on their faith imposed by otherwise perfectly appropriate statutes. And courts thereafter gave judicial exemptions to Saturday Sabbatarians and Amish ascetics and Jehovah's Witness pacifists and other parties. The 1990 Smith neutrality test largely closed the door on these judicial exemptions, unleashing a myriad of legislative exemptions which the court has assiduously enforced. The court has, for example, interpreted the Religious Freedom Restoration Act, shorthand RFRA, to grant exemptions to both religious individuals and religious groups. Most notably in the 2014 Hobby Lobby case, the court used RFRA to grant a closely held business corporation a partial exemption from compliance with the Affordable Care Act that mandated employees carry insurance for abortifacients, contrary to their owners' beliefs about the sanctity of life. The court has also interpreted the Religious Land Use and Institutional Persons Act, RLUIPA, as we lawyers like to say, to protect the religious worship of prisoners, to exempt them from full prison grooming requirements, and to permit chaplains to pray for and even lay hands on believers in death chambers. The court has pressed civil rights prohibitions on religious discrimination to protect a Muslim job applicant from prejudicial hiring practices and a Sunday worker from a retaliatory firing. And in the 2012 Hosanna Tabor case, the court has lifted the constitutional command, the traditional statutory exemption under the Civil Rights Act that allowed religious employers to hire their own faithful in making decisions about who is in their community and workplace. In a world of growing religious pluralism and growing anti-religious animus, religious freedom exemptions are essential, if always controversial. What has made them more controversial of late is when majority faiths seek judicial exemptions after failing to get them from the legislature. Judicial exemptions used to be justified as a suitable refuge for religious minorities, protection from what James Madison called the tyranny of the legislative majority. They're now sometimes claimed by majority faiths too. What has also made exemptions more controversial is when granting the exemption causes harm to some third party. In cases like Masterpiece Cake Shop and Creative 303, the harms imposed by the exempted conduct might be real to the victims and their dignity, but they're far more attenuated, if not staged, especially when so many alternative bake shops and websites designers are at hand. When parties are exempted from delivery of more vital services because of the religious scruples of the claimant, that can become more problematic. I want to save a little time, so I'm going to pass over separation of church and state. It's all nonsense anyway. I want to instead get to a few concluding reflections so we have some time for Q&A with you, which is the much more fun part, instead of listening to some bald guy yelling at you. Constitutions work like clocks, American founder John Adams once said, and to operate properly, their pendulums must swing back and forth and their operators must get wound up from time to time. We have certainly seen plenty of constitutional operators get wound up of late about religious liberty, and we have witnessed wide pendular swings in First Amendment jurisprudence. But despite the loud criticisms from the Academy and from the elite media that continue to dominate the headlines, the U.S. Supreme Court has ended the 3 decades-long constitutional swing of cases away from religious freedom and led a strong pendular swing back in favor. Since 2011, almost every one of the 24 Supreme Court cases on point have advanced the cause of religious freedom. And those cases have been echoed and extended in scores and sometimes hundreds of lower federal and parallel state court cases. The court has not always produced clean and clear and clockwork logic, nor has it settled on a grand unified theory that some of the justices and academics like Rick Garnett have been advocating. But the court has produced a long, hard swing in favor of religious freedom, even if that swing is sometimes a bit wobbly. This has been, to my mind, a good movement. Religion is too vital a root and resource for democratic order and rule of law to be passed over or to be pushed out. Religious freedom is too central a pillar of liberty and human rights to be chiseled away or pulled down. In centuries past, and in many regions of the world still today, disputes over religion and religious freedom have often led to violence and sometimes to all-out warfare. We have the extraordinary luxury in America of settling our religious disputes and vindicating our religious rights with patience, deliberation, due process, and full ventilation of all the issues on all sides. We would do well to continue to embrace this precious constitutional heritage and process. As this process continues to unfold, it is essential, in my view, that the full range of religious freedom principles remain in operation. Liberty of conscience and freedom of exercise and religious pluralism and religious equality, separation of church and state, and no establishment of religion by state law. Religious freedom norms should not be diluted into mere neutrality or mere equality norms alone, nor should they be weakened by too low a standard of review or too high a law of standing. It is essential that America addresses the glaring blind spots in our religious liberty jurisprudence, particularly the long and shameful treatment of Native American Indian claims, and the growing repression of Muslims and other minorities, which are not being addressed very well at the local level and in some circuits. It is essential that we show our traditional hospitality and charity to the sojourners in our gates, migrants, refugees, asylum seekers, and others, and desist from some of the outrageous nativism and xenophobia that have marked far too much of our popular and political speech of late. It is essential that we balance religious freedom with other fundamental freedoms, including sexual and same-sex freedoms, and find responsible ways of living together with all of our neighbors in civic life, to be sure, oftentimes with sturdy fences between us. We must desist from mutually destructive strategies of defaming and demonizing and destroying those who have contrary views in public. It is essential that religious liberty advocates not overplay their hands. It is often extreme cases that trigger a reverse pendular swing and short-term victories that push the court to a reductio ad absurdum in one case produces strong backlash that can sometimes take a full generation to stop and reverse. It is essential that majority Christians today, who have won most of the recent cases, remain gracious in victory, especially to those who do not share their faith. This is not only the heart of the Golden Rule, but American Christians must be aware that they will soon be in the minority. While religious freedom is rising, religious allegiance is falling, at least off of the Notre Dame campus. We need to remember that the rules that we craft now for religious minorities are the rules that will govern the religious liberty of our grandchildren. And Catholics in particular, who now enjoy such remarkable political and cultural power, would do well to remember that it was less than a century ago that Catholics were a hated, persecuted, and reviled minority in much of America. That day could well return for us people of faith, doing unto others what is loving and what is just is not only right, it is also expedient. It is essential that we treat religious freedom as a precious gift of God to protect, not a prerogative of one particular party to brandish. Put not your faith in princes, the Bible tells us, and by extension, put not your religious freedom in the hands of politicians, or reduce this precious gift to an applause line or to a plaything of the political process. And finally, it is essential that we Christians in particular use our religious freedom wisely to return to our most cardinal callings of preaching the word, administering the sacraments, catechizing the young, caring for the poor and needy, prophesying against injustice. Happily, that still takes place at a lot of places. But like many other institutions, many American Christian churches have been devastated by human sinfulness. Think of the clerical abuse of minors, the embezzlement of tithes and gifts, the degradation and mistreatment of women, indifference to the poor and the needy, a lack of compassion in matters of sexual orientation, racially and economically segregated congregations, inhospitality to the outsider. Our failure as Christians to live up to our own truths and values rightly undercuts our moral authority in the eyes of others, and it also weakens the claim of religious freedom for ourselves and for all others. Contrition, confession, restoration, reform, and return to the classics, to the ideals, to the calling of us people of faith is the better path. Martin Luther King Jr. once said that the church is not the master or the servant of the state, but rather the conscience of the state. When their own houses are in good order, churches are still well situated to play this important prophetic role in modern American societies. As Dr. King reminded his listeners, with which I end, if the church will free itself from the shackles of a deadening status quo, if the church will repent of its failures and return to its great historic mission, if the church will speak and act fearlessly and insistently in terms of justice and peace, it will rekindle the imagination of humankind and fire the souls of men and women, imbuing them with a glowing and ardent love for truth and justice and peace. Men and women far and near will know the church as a great fellowship of love that provides light and bread for lonely travelers at midnight. Thank you very much.
We have a tradition here at the center where we invite our undergraduate students to ask the first question. Now, as everyone here knows, I'm a little bit skeptical of evolving constitutions, but being here in the law school, we should include the law students as well. So any students, undergraduate or law students, very question. Okay, stand up and tell us your name, please.
My question is about state funds to schools, religious schools in particular. I've heard of many times where when a school or really any religious organization receives funds from the state, they're then required to follow certain laws of the state or the federal government, such as Title IX, which might impinge on their religious freedom in, for example, hiring. And I think that is a pretty common thing. So what is happening in regards to that? Is that still upheld as being okay, even though it seems to impinge on religious freedom?
Yep, excellent question. Thank you so much. I hope everybody heard it. The question was, yes, it's nice to talk about state funding for religious schools and other organizations, but those funds oftentimes comes with conditions, and the conditions include, for example, Title IX restrictions on the kind of hiring that one can do, and sometimes other conditions that are imposed by government as a precondition to getting the funding and as an ongoing monitor for how the funding is used. There's no question that that is one of the dangers of being dependent upon the state for largesse, whether it be property, funding, or other kinds of goodies that the state gives you. Increasingly in our day, this is not a free lunch. This is instead sometimes a way of inducing religious organizations internally to make changes they may otherwise not want to make. And for fat cat organizations like here at Notre Dame and some of the other major religious institutions, that is one reason not to simply accept government funding, because it's not worth the hassle. There are countervailing measures. One important countervailing measure was one I mentioned in passing, introduced by the Hosanna v. Tabor case and illustrated again in the Lady of Guadalupe case in 2012 and 2020, which says that, look, it is a constitutional command of both the Establishment and the Free Exercise Clause to allow religious organizations to hire whom they wish on especially matters of religious leadership. You cannot force the local synagogue to hire the Catholic priest to read the Torah, and you can't have the local Catholic church be forced to hire the Lutheran minister, however good they might be, to lead the Mass. You simply cannot do that. And the thought is that that violates the core integrity of those religious organizations and is a form of bribery beyond the pale. And so there are countervailing rules that are in place now, either statutory or constitutional, that put limits on what the government can insist on as a condition for getting or using the funds. But there is no question that the danger of having the state as one of your benefactors is that the distinctive quality of you as a religious organization may well be imperiled by the kind of expectations the state imposes on you. And if that sounds a little hyperbolic, you can go up to Canada, into Quebec or Alberta or some of the other states, provinces, and you can find that not only is it funding, but even accreditation, to be accredited as a school that is recognized as a place where students through mandatory school attendance orders can go, even accreditation is now conditioned on a number of teachings that have to be administered, even contrary to your beliefs, a number of certain practices that you have to engage, which are contrary to the way that you think about, for example, gender relations, a number of services that have to be made available to students, sex assignment, translation, transfers and the like, all of which in some context are now conditions for getting accreditation, let alone funding. So it is a dangerous game to start taking state funding. Now, one response is, beyond the measures of protection and conditionality, another response is to say, at the political level, you cannot lard these forms of largesse for education with all these conditions. Come on now, we have religious pluralism, we recognize that as such, we have educational pluralism, we have choice, and the thought is that to the extent there is education going on in the institutions receiving the funds, you can't tell them what they're supposed to do internally. You don't tell a local school district in Baltimore exactly how to run its show, and you don't tell the parochial school or the parish school in a particular community how it runs its shows when it gets a few $1,000s to buy new Bunsen burners or lab equipment or computers. There's a strong political argument that needs to be made in the state and federal legislatures as a further prophylactic against the worries of that conditionality.
Another student question? Stand up and tell us who you are. Hi, my name is Mohr. I'm also curious about educational policy and law, especially as we see like going in Oklahoma and the front of St. Isidore's school and the reality of other options, in this case charter schools. This law school has contributed to that front somehow, in some effects. And so what do you see about the forecast of litigation there and the future of establishment cost concerns with regards to those actors being public or not? Yeah,
so the hermetic distinction that we used to draw, if not hermeneutical distinction, between public and private education, I think is eroding. I think it's eroding in part for some of the reasons I passed over, which is the division between public and private, state and non-state, is getting more and more porous as we enter into 21st century society. And that manifests, amongst other things, in the public versus private school. COVID, if nothing, has taught us that there are alternative ways of having education, and it's underscored a lesson that a lot of people have already been pressing for a long time about the importance of religious choice. The Garnett family here, the Jack Koons and his work in the old days, people like Ashley Berner have been pressing the argument to say that education is a public good to be delivered in a number of different vehicles, and we need to recognize private schools, home schools, public schools, and then hybrids amongst them. You can have a hybrid homeschool and public school, as COVID forced us to do, a hybrid private school and homeschool, as COVID forced us to do, and we can also now imagine charter schools that are predicated on the delivery of quality education, that are run by religious folk of various sorts, sometimes multiple faith communities, sometimes individual faith communities, and those charter schools are offering an alternative option. I think in the current climate of a turn-down establishment clause, which 30 years ago would have destroyed this ab initio, a turn-down establishment clause, I think, opens windows and opportunities for this kind of experimentation which in my view is healthy and robust. Inevitably, it's going to be challenged constitutionally, as you know from the work of the Church, State, and Society program and others. But I think there's pretty good hope, at least in some circuits and amongst 5 or 6 justices of the Supreme Court, that this kind of experimentation in the delivery of quality education is a good thing. This is a step beyond vouchers, which had left the thing to the parents to decide. This is instead saying, rather than giving it to untutored parents to make decisions, often in desperation for where junior should go, maybe it's better to put those same dollars in the hands of people that know how to do education and can hold out a realistic option in a charter school environment, in a magnet school environment, in other kinds of these hybrid school environments to foster better educational choice and indeed better education. There's going to be playing at the edges. Can you use the state's money to catechize the young? Can you use it to run the chapel or a chaplain in that religious school? Can you use it to buy sacramental vessels for the Eucharist? We're going to fuss with that for 20 or 30 years. But that's just normal parts of the edges of what is a principle that, in my view, is healthy, welcome, and long overdue.
We have 10 minutes left. We'll try to get as many questions and answers.
And I'll be briefer in answers.
So stand up and tell us where you're at in Notre Dame.
My name is Pam. I'm a 2L here. So my question relates to the symbols context.
Right.
The symbols context. So your first teaching. It's certainly a welcome development to shift to the null hypothesis, what you called, that kind of strong presumption in favor of symbols that are long-standing. And you mentioned a case like American Legion reflects sort of a wider shift, particularly with Justice Alito in that case in particular, towards upholding and allowing democratic local state governments to reflect, you said, the values of the community. But I wonder, in his reasoning in similar cases, in order to reach that reasoning, the symbols need to be sufficiently desacralized. So Justice Alito talked about how the cross was not necessarily like a representation of Christ's death, but it was long established views in the community. Yeah. And so I wonder how much of this is a shift towards the religious liberty of the founding era versus more just like broader sensibilities of liking history and tradition as opposed to saying this community was majority Christian or that sort of reasoning. Those two things seem to be kind of distinct. Anyway, I'd just be curious.
Yeah, so very good question. A wide range of things there. Perhaps people could hear it, but for the tape, our 2L colleague here asked a very bright question about what do we think about these religious symbolism cases? Does the cost of holding a religious symbol in public life is the cost for upholding a religious symbol in public life basically de-theologizing, desacralizing, denigrating the religious significance or origin or significance of that religious symbol as a condition for getting establishment imprimatur? I think it's a very good question. I think the court used to do that a lot. We used to kind of simply de-theologize, desacralize as a matter of course, and simply say the creche is just a nice thing at Christmas, prayer is just a kind of brief invocation of good things, a Ten Commandments display is just a cool moral code that happens to come from Sinai. We used to do that a lot, and it was insulting for people of faith, for whom that symbol represented something highly, highly significant and indeed spiritual. I think the court, since the Van Orden v. Perry case, with Chief Justice Rehnquist, probably with Rick Garnett's writing the opinion for him, Chief Justice Rehnquist kind of said, we got to stop this business of de-theologizing. And we have to recognize a Ten Commandments display is a Ten Commandments display. It says it right there, I'm the Lord thy God who brought thee out of the land of Egypt. It's a symbol, it's a religious symbol. Of course it is. The question is whether it's only that, or whether we can have alternative meanings and interpretations. And it's not so much about readers' response. It's rather that when we put that religious symbol in a public setting, does it take on additional religious and non-religious significance for the others around it? And the argument, I think, becomes eventually, in a democratic polity, which represents all the values and beliefs of its people. We represent their religious values and beliefs that they have, even while those symbols have other kinds of significance for other people too. I think that's healthy, in my view. I think it's much better than the old bricolage approach, which for a while the Supreme Court says you can have a baby Jesus, but you gotta have 3 plastic reindeer. Right? You can have a Ten Commandments display, but please, 10 other secular documents around it. That's insulting. That's insulting to the people who are putting up the display, insulting to those who take religious significance from that. And I think the court has evolved into a position that is better, healthier, but you have to agree that these religious symbolism cases have been and are a mess. I think the court is coming around to a position about history and tradition that I think is healthier. I think the court separating out what might be offensive from what is unconstitutionally coercive, I think, is helpful. I think the court in toughening the standing requirements a little bit for those who would use the Establishment Clause as a heckler's veto against some of these old practices have all been healthy developments. They are not a full solution to, I think, some of the silly opinions from Lynch v. Donnelly all the way through to the 2005 cases, McCreary County versus ACLU in particular, but I think there's healthier moves in the recent case law, which is what I was lifting up.
Please, sir.
Dennis Michael, law student here. Critics of what you described, I think rightly, as the Great Awakening, have critiqued it as the court's articulation of a most favored nation or most favored right status for religious liberty, especially in light of the COVID cases. I'm wondering if, as a descriptive matter, you think that critique is persuasive, that the court now is favoring religious claimants in the way that it's not with respect to other litigants, or if you think it's just a new perception that religious people are now being treated on equal terms as others, but because of maybe the last 30 years where they weren't treated so equally, it now seems to be a form of favoritism.
Yeah. So is this most favored nation status for religion and religious freedom, or is it simply a return to some kind of equality regime where religious freedom sits alongside other freedoms in the Constitution? In my view, it's the latter. I don't think the Supreme Court is in the business of saying religion uber alles. While the court has done a number of corrective decisions in this spate of 24-odd cases from Wynne all the way through to Graf v. Joy, the court, I think, has, for the most part, been incrementalist in its return to what, in my view, was the more salient teaching of the 1940s and 50s and salient teachings, as we'll talk about tomorrow, of the founding era. I think the founding generation took religious freedom seriously. And whether they thought it was the first freedom or an important freedom or a fundamental freedom, historians will debate about that. Religious freedom was thought to be sufficiently important that it needed to be ensconced not just in state constitutions, it needed to be ensconced in the federal constitution as well, and it needed to be ensconced as a guarantee, especially against Congress and this new national government we're creating in preventing that government prescribing or proscribing religion. I think back then, to the extent that was most favored nation, there's nothing more favorable now than it was back then in the 18th century, and in a court that's seeking to hew to the text and traditions of the First Amendment. I think what the court is doing is correcting. You can think about this as a religious affirmative action program rather than a most favored nation pocket agenda by five geezers in black bathrobes.
We're going to squeeze in one more question. We just have 2 minutes left. Please, ma'am.
Hi, I'm also a law student here. I'm wondering, as the court has punted largely on answering the question of what is religion,
Yep.
they haven't provided a definition. Do you think as we enter into a more and more pluralistic society that that's necessary? And if so, what would that look like?
Yeah, boy, that's a hard one. I'm glad Paul Weithman is here. He's the political philosopher who can answer these things with philosophical fluidity. I think the court has properly eschewed trying to give a blanket definition of what is religion, like the IRS does in trying to determine whether a religious claim or claimant or deduction or organization can be viewed as religion. And they have a 15-point checklist, and you have to have 9 of 15 before you pass from the world of non-religion to religion. I think we have to avoid that. I think what the court has, tried to do is to balance the claim of religion made by the party that marches into court and has used sincerity and good faith and demonstration of substantial burden as one screen on what is allowed to be pressed as a free exercise or a statutory religious freedom claim. I think the court will indulge charlatanism as a necessary cost for providing religious freedom for all, in the sense that the court will say, you will get your day in court if you want to plead it under the free exercise clause. And we'd rather have you have your day in court and lose than deny you a day in court because we don't think ab initio that your claim is religious. I think that is a generous way of thinking about religion, and I think it's, in my view, a proper way in terms of encouraging the ongoing expansion of the American constitutional experiment. We have philosophers like Paul Weithman. We have great scholars like Sam Bray who can give us a really ornate definition of religion. We have philosophers and theologians and anthropologists and sociologists that will demonstrate all kinds of different ways in which we can do that. We can use the argument of the International Human Rights Framework that called for 4 C's. You need a creed, you need a confession, you need a code of conduct, and you need a confessional community. Well, if you do as a 4C framework, we would then all of a sudden foreclose all kinds of religious claims in place. So, in my view, there is no definition of religion. There is a boundary line between religion and non-religion, as the founders say, and as the First Amendment dictates. There is an invitation for those of faith and non-faith to consider alternative constitutional vehicles to press their constitutional claim. Free speech and free press, especially speech, have been important lifeboats for religious freedom during a time when the free exercise clause was largely foreclosed. And the idea there would be, if you can find an alternative vehicle for a time, it's better to press a free speech claim or a statutory claim than to press a free exercise claim. The harder part of this story is the flip side of the Establishment Clause. Because look, we tend to want, as just a matter of generosity and goodwill and charity to our neighbors, to say, look, any sincere good faith claim of religion should be given its day in court. And free exercise of religion should be something that we seek to protect. But the very definition of religion that we operate within that free exercise space is the definition of religion that needs applied to the Establishment Clause as well. Because there is one term, religion, in the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And look, thereof, it's not even a separate word, it says thereof. That is, there's one term. And if you want to be consistent, the generosity with which you accord free exercise claims is a strangulating regime that you've imposed on the government. If government can't do anything respecting an establishment of religion, and religion is everything that is sincere and in good faith, then what really can the government do? So we're struggling as a consequence to try to find a coherent, integrated framework for thinking about religious freedom. My old law professor, Larry Tribe, said, well, just make it easy. There are two terms there and have two definitions. A wide, generous one for free exercise and a narrow, manageable one for establishment. And even I, dumb law student as I was, thought, that doesn't make a lot of sense. And it doesn't philosophically. But I think pragmatically and practically is effectively what the court has done. Generous free exercise rights, even for the atheist, even for the agnostic, even for the bizarre, even for the new, even for the exotic, and relatively modest definitions of religion as a set of limitations on what government can do. It's a pragmatic but very, very uncomfortable position the court has put itself in its taxonomy of what religious freedom is about. There's a good new book by Nathan Chapman and by Michael McConnell about the Establishment Clause. Agreeing to Disagree, I think is the name. I would recommend that because they parse this stuff in some detail, trying to kind of sort out how do we think about this in a framework that makes sense. They ultimately resort to the same thing that Philip Munoz resorts to, which is kind of a natural right of religion. And the natural right of religion is something we're trying to protect through both limitations on what government can do and on limitations on what government can forbid. And the thought there is that natural right flourishes best when these limits are imposed upon government. That's a powerful originalist argument and a powerful ongoing argument, with the difficulty being a lot of people in the 21st century think pox on natural rights, unfortunately. That's a very complicated.